I'm Fred Tran, the Deputy Director of the Richmond Rent Program. This presentation will provide information on understanding evictions in Richmond. Richmond City Council adopted Urgency Ordinance number 02-21, known as the Eviction Moratorium, on March 23rd, 2021. The eviction moratorium establishes a temporary moratorium on certain evictions in Richmond through a local emergency and 60 days thereafter. The urgency ordinance prohibits landlords from evicting residential tenants in most circumstances. Please review the ordinance on our website and contact our program with any questions. Urgency Ordinance 13-22. There are 4 grounds allowed for evictions while the urgency ordinance is still in place. Number 1, a nuisance which poses an imminent health or safety threat. Number 2, the tenant has failed to pay rent. Number 3, the Ellis Act, where the owner intends to remove the residential real property from the rental market. Number 4, an owner or relative move-in. There are additional requirements both under California state law and the Richmond Rent Ordinance for each of these 4 reasons. For further details, please contact our office to discuss or speak with an attorney. The Rent Ordinance has 2 main components: rent control and eviction protections. In the next slide, I will discuss what types of properties are covered under each. I will also provide details on rent control and just cause later in the presentation. Rent control means landlords cannot charge above their maximum allowable rent, also known as MAR. Maximum allowable rent is calculated as the base rent plus annual inflation adjustments. Maximum allowable rent can be adjusted upwards or downwards through a petition process, which we will also discuss later. Just cause means the landlord cannot evict without a cause. There must be one of the 8 causes presented here on the slide for grounds to evict. How does the rent ordinance apply to different types of properties? We'll start from right to left with fully exempt properties. Some properties are fully exempt from the rent ordinance, meaning rent control and just cause do not apply. These include room rentals in the landlord's primary residence where the landlord and tenant share a kitchen or bathroom, an owner-occupied single-family home where the landlord rents out a permitted accessory dwelling unit, and retirement homes. The next type of property is partially covered. These properties are under just cause for eviction protections, but not rent regulated. These include subsidized units, including Section 8 and properties exempt under the state's Costa-Hawkins Rental Housing Act. Costa-Hawkins exempts property with single dwelling units on a single parcel and new construction properties built after February 1st, 1995. Single dwelling unit properties refer to condominiums and single family homes where there is no subdivision or in-law units. Multi-unit properties such as duplexes and larger built before February 1st, 1995 are subject to both rent control and eviction protections. Next, I will discuss compliance requirements for the just cause evictions. A landlord needs a just cause reason to evict. There are the 8 just cause reasons presented on this slide. A lease termination and sale of property are not just causes to evict. The first 4 listed here are at-fault evictions, where a landlord alleges the tenant has done something to lead to a termination of tenancy. In all cases, a tenant must have the opportunity to correct the issue, for example, pay their rent that is due, or correct a lease violation. The second 3 are no-fault evictions. These evictions are when a tenant has not allegedly done anything wrong, but the landlord wants to recover possession of the unit. Because these are considered no-fault evictions, they require either temporary or permanent relocation payments to the tenant. Relocation payment amounts depending on various factors, including the type of eviction, the composition of the household, and the size of the rental unit. The relocation fee schedule can be found on our website and will be discussed later. The last one, temporary tenancy, is when an owner wants to rent out their primary residence for less than 1 year and plans to move back in. This is only for single-family homes and condominiums. The landlord must inform the tenant that the rental is temporary prior to inception of tenancy and file paperwork with the rent program. For the first 4 mentioned just cause that pertain to tenant's behavior, the landlord must also serve the tenant with a written warning notice prior to serving a termination of tenancy notice. This warning notice gives the tenant a chance to cure the violation within a reasonable period, minimum 5 days, to respond to the notice in some manner. If the tenant does not comply with the warning notice, the landlord may proceed to the next phase of the termination of the tenancy. Any termination of tenancy notice must be filed with the rent program within 2 business days after serving the tenant, along with a proof of service form. If the termination is for breach of lease, nuisance, or failure to give access, the landlord must include the initial warning notice as well. The notice should be submitted through our online rental portal. For properties with 5 or fewer units, the landlord may submit by mail or in person. Failure to file a termination notice with the rent program can be a defense for a tenant in an unlawful detainer proceeding. I will next discuss examples of reasons that are not considered just cause. The mere expiration of a lease agreement, especially where the contract says that the tenant must move at the end of the lease, is not a just cause. The sale, transfer, or foreclosure of the rental property is not considered a just cause. The tenant paying below market rent and the landlord wanting to evict the tenant to reset the rent is not a just cause. If the landlord makes a unilateral change to the terms of the tenancy and the tenant violates that unilateral imposed term, is not a just cause. Finally, if the landlord reasonably denies a replacement roommate and then tries to evict for subletting, is not considered a just cause. Presented are the web pages for a fact sheet for both landlords and tenants. Also, there's a link that provides the latest information on COVID-related rental laws. Please review and contact our program with any questions. Presented here is a link and listing of rental assistance that is still available for Richmond tenants and landlords. Please contact our program with any questions or referrals. Please review the flow chart of the potential court process for non-payment of rent. The rent program does not get involved with the actual court process. This is informational and should be used more as a reference. For more assistance with the court issues, we suggest retaining legal assistance. There are 2 no-fault evictions available as mentioned under the just cause for evictions. One, an owner move-in, and the second is withdrawal of the unit from the rental market. The rent program has created a separate presentation for owner move-in evictions. Please view our webpage for the workshop. I will discuss some brief elements of the owner move-in. This is when the owner wants to recover possession of the rental unit as their primary residence for the owner or owner's spouse, children, parents, or grandparents. The owner is considered an actual person who owns at least 50% as recorded of the ownership with the county. Tenants must have first right of refusal to return to the rental unit if ever placed back into the market. Owner move-in forms may be downloaded from our website for a 60-day written termination notice. The owner or relative must occupy the unit as a primary residence for at least 36 consecutive months. Relocation payments, rent charged, and protections for being over 62 years old, disabled, or certified as being terminally ill by the tenant's treating physicians will also be discussed in the following workshop. I will next discuss the withdrawal of the unit from the rental market known as the Ellis Act. The Ellis Act is a California law and part of the Richmond Rent Ordinance. The Ellis Act provides landlords with a legal way to remove the unit from the rental market. The act was adopted by California legislature in 1985 after the California Supreme Court decision in the case of Nash versus the city of Santa Monica. For more information on the Ellis Act and the detailed 10 steps, please visit the presented website. Presented are some critical aspects of the Ellis Act. The tenant must be served a written notice for withdrawal from the rental market. The owner must give the tenant no less than 120 days for the tenant to vacate the property. Qualified tenants are entitled to a 1-year notice if they are a senior, disabled, have at least one dependent minor child, or considered low-income households, and have been residing in the unit for at least 1 year prior to the date of delivery of the notice of intent to withdraw to the board. If the tenant is qualified and wants the 1-year entitlement, they must return the notice of entitlement to a 1-year notice within 60 days to the owner. For rent-controlled properties that are being rented again after withdrawal from the rental market, the following shall apply. If the property is offered for rent within 2 years from the withdrawal, the owner shall, 1, be liable for actual and punitive damages to any tenant displaced by the property being withdrawn. 2, must offer the unit back for rent to displaced tenants. For rent-controlled tenancies, if within 5 years after withdrawing the unit, the property is reoffered for rent, that property shall be offered back to the vacating tenant at the rent in effect when the property was removed from the rental market. An annual general adjustment rent increase may be applied if the tenant moves back into the rental unit. For non-rent controlled tenancies, the landlord must still offer the unit back to the tenant who is evicted. However, the rent charge can be set to market rate. If the property is demolished, reconstructed, or offered for rent within 5 years from withdrawal of the rental market, the newly constructed unit shall be subject to rent control. If the property is offered for rent within 10 years from withdrawal from the rental market, the owner shall notify the rent board and offer the unit back to the tenant who was evicted. The city of Richmond also has a relocation ordinance, and we will discuss some of the details. A landlord must provide temporary relocation payment assistance when a tenant must vacate for substantial repairs, or a government order has been issued, or the tenant is forced to vacate due to a health or safety concern. Notice of entitlement to temporary relocation payments must be provided with the notice of termination of tenancy. The relocation payment amount is determined by a resolution of the city council. Presented are the per diem temporary relocation payments for 2023. You can also visit our website presented to view the most updated information as they change annually. Next, I will discuss the permanent relocation payments. These must be provided when a tenancy is terminated due to an owner move-in or withdrawal from the rental market known as Ellis. Also, for extenuating circumstances from government orders to vacate for health and or safety conditions. A notice of entitlement to relocation payments must be provided with the notice of termination of tenancy for owner move-ins and withdrawal from rental markets. The amounts determined are by resolution of the City of Richmond City Council. Presented on this slide are the permanent relocation payments for 2023. You can also visit our website for the most updated information. Next, I will discuss important tips on evictions. A self-help eviction is when a landlord locks a tenant out, cuts off utilities, or otherwise takes their own action to terminate the tenancy without going to court. Self-help evictions are illegal in California. A landlord must proceed with an unlawful detainer process to receive a judgment from the court. If the tenant does not vacate, the sheriff can evict with a writ or a judgment. Evictions can be highly technical. It is recommended to consider speaking to legal counsel to better understand the process and current laws. It's best to learn about tenant and landlord responsibilities and educate yourself both with California and Richmond eviction laws, and possibly have an attorney represent you in court. No-fault evictions, such as owner move-in and withdrawal from rental markets, are complicated. No-fault evictions require special noticing, permanent relocation payments, and may provide special rights to tenants, such as the right to move back in at the rent paid when vacated, and additional protection for status of qualified tenants. Both tenants and landlords should take an eviction seriously. Contact the Richmond Rent Program as soon as possible if you receive threats of an eviction, warning notices, actual termination notices, or court documents for an unlawful detainer. If you are a landlord, contact the Richmond Rent Program if you are considering issuing any of these notices or documents. The eviction process has firm deadlines, which, if not met, can lead to a tenant being evicted. If an unlawful detainer complaint is received, a tenant generally only has a certain number of days to respond with an answer to the unlawful detainer. If a tenant does not file an answer to the unlawful detainer with the court within the allowed time, a judge may enter a default judgment against the tenant. It's best to be a tenant in good standings. Prior to just cause eviction protections in Richmond, tenants could be evicted without cause. Tenants should avoid giving the landlord any reason to evict. Thank you for viewing this workshop. Please contact our program with any further questions.